Go.
Here we are.
Okay, good morning, everybody. Thank you so much for joining us today. I'm Christy Lawler. I'm the Gifts and Wills Manager here at the St. Vincent's Foundation, and I have David Davis, who's the Principal Solicitor at Davis and Haven Legal.
Yes.
There we go. Apologies, David. So before we begin, I would like to acknowledge the traditional custodians of the land on which we meet today and on which our many sites are located, and I pay my respects to elders past and present. We are thrilled to have so many wonderful supporters with us today, and I thank you all for taking time out of your busy day to be with us. So the webinar will run for 45 minutes and it's being recorded, so we'll share a copy of the webinar in the coming days with you. And if you did enjoy it, please do share it with friends and family. Thank you also to everybody who submitted a question during the registration process. So I've actually shared these ahead of time with David, and he has actually incorporated them into his presentation today, which is wonderful, and we're very grateful for him to do that. Now, today's webinar follows on from our previous webinars, which are available on our website. And so should you wish to watch them either for the first time or as a refresher, we would love to see you there. But please do remember that the information on these webinars is of a general nature and it is not to be taken as legal or financial advice. So today we are discussing the intergenerational wealth transfer and why proactive estate planning is more important than ever for ensuring that our wishes are protected and that our values continue beyond our lifetime. And the best estate plans, they're built years before they're actually needed, and they focus on reducing conflict, protecting vulnerable beneficiaries, preserving tax efficiencies, and creating a meaningful legacy for our future generations. Now, you may have heard that Australia is currently experiencing the largest intergenerational wealth transfer in our history. But what does this actually mean? So over the next 2.5 decades, economists are predicting that an estimated $5.4 trillion is expected to pass from one generation to the next through inheritances and lifetime gifts. So this figure may seem astronomical to most of us, but when you do think about it, the average price of a metropolitan Melbourne home is now over $950,000 compared to $350,000 just 20 years ago or in 2026. And what has driven the largest intergenerational wealth transfer and this $5.4 trillion? So much of Australia's household wealth, it's held in superannuation and on property. And decades of rising property values, together with the maturity of the Australian superannuation system, have significantly increased the value of many people's estates. So as a result, many Australians are asset rich, even if they do live relatively modest and have relatively modest day-to-day incomes. So as many of us do begin to think about how we will pass our estates on to the next generation, it also gives rise to an incredibly important question. What is the legacy I want to leave? And in my role as the Gifts and Wills Manager at St. Vincent's, I have the extraordinary privilege of witnessing the impact that gifts from wills have for our patients, our staff, our researchers, and our healthcare services. Some of the most touching moments I witness in my role is when families come together to plan these decisions, and then when the family returns to see the impact their loved one has created through a gift in their will for St. Vincent's. And I think sometimes there is a perception that we have to choose between providing for our family members and supporting the causes we care about when making estate plans. But in my experience, this simply isn't the case. Many of the bequests we receive provide for family and for friends first, and they also include a gift for St. Vincent's and other charities that reflect the values and the passions of the person who made that will. To me, it is one of the most meaningful aspects and elements of estate planning. It isn't just about passing on your assets, it's about passing on your values as well. Now, I do have a short example, and just one example that I'd love to share with you if I may. So Doug was a supporter of St. Vincent's for many, many years, and his values resonated resonated strongly with him. He had close personal ties to St. V's and saw firsthand the care and compassion we provide to every person in need. So Doug was a widower and he had kindly included St. Vincent's in his will. And due to conversations that I have with Doug and other colleagues have with Doug over the years about the areas that he felt passionate about and where he would like to support, we were able to direct his bequest gift to those areas when this time did sadly come. So we divided Doug's bequest between two key areas. One was our respiratory department and the other was our pastoral care department. So our respiratory department, they've used Doug's gift to purchase a piece of medical equipment for patients who are presenting with asthma symptoms. And this will go on to save lives. And our pastoral care department have used Doug's gift to purchase comfort baskets for our palliative care patients and have also created art trolleys, which will offer patients an artistic art outlet during their stay in hospital. And as you can imagine, if you're staying in hospital for any length of time, having creative opportunities available really could make the difference for your mental health. So when I called Doug's daughter recently to share the impact of her dad's kind bequest gift to St. Vincent's, she was extremely touched. Asthma was medically close to their family, and her mum was artistic and loved to paint. So Doug's daughter believes that her parents would have been thrilled to know their legacy gift was being used to save lives and bring comfort and joy to patients while they were at their most vulnerable. So gifts from wills, they play a crucial role at St. Vincent's, and the impact is felt by our patients, our staff, and our healthcare sites, as I mentioned, and it will continue to do so far into the future. We are so grateful to the incredible people who have chosen to include St. V's in their estate plans, and the weight of that decision is something we take very, very seriously. Estate planning is not simply about deciding who receives your assets. It's an opportunity to pass on the values that have guided your life. By caring for loved ones and supporting the causes that matter most, you can create a legacy that reflects who you are and continues to make a difference for generations to come. So today, I am delighted to share estate planning highlights and insights from David Davis, who, as I mentioned, is Special Counsel at Davis and Hayden Legal. So for over 35 years, David has acted for clients on a range of matters, including estate and business succession planning, companies and trusts, including variations and restructuring, estate administration and estate litigation. He has contributed to policy at a state and federal level regarding powers of attorney and advanced care directive, and he regularly presents at state and national conferences. So David, I am delighted to pass the floor across to you.
All right, thank you very much. Now, how do I bring up my...
I will do that now for you.
All right.
So, I'm going to go share.
All right, now I'm hoping everyone can see this. Following on from what Christy said, it is the largest intergenerational wealth transfer in history. And I'm focusing on estate and in a couple of months since the federal budget came down on the 12th of May, which has thrown things into pretty much a new phase of estate planning, which means that what we're looking at is having to be aware of these changes, some of which have been proposed but are still not reflected in the legislation. So what I've done is to go through and give an overview only, but I also want to mention that there are some people who put in questions, and it deals with a range of areas, which I want to acknowledge. So where do the trusts fit in? What can you do to protect assets in a blended family? What can we do for tax reductions? Best way to pass on investment properties to children? How to create generational wealth? Testamentary trusts? And one question that I won't be able to answer here is about an industry superannuation in pension phase to roll over into an accumulation fund. But that gets into advice. This is not advice, this is information. So what I can do is, to the person who posed that particular question about the pension and the accumulation fund, I can send a list of other information I'll need to actually answer that properly, and we can talk and work out a time and perhaps even a price for that advice. So we're ready now to go on with the show.
We are just having a little bit of technical, so maybe carry on.
Oh, I'll carry on.
And
all right.
Apologies.
All right. Now, what I propose to do is look at the following matters. My introduction is to look at, I'm a lawyer, trust me, but only to the extent that I'm able to give information on what the law means. And it's not necessarily the right or wrong answer, but I'll answer your questions based on my understanding of the law, and the answers may not be satisfactory, and that's because the law, in some cases, is unclear, and that's the way the law is. I also want to go with a quote from Justice Oliver Wendell Holmes Jr., who was on the Supreme Court of the United States at the turn of the 20th century. And he said, "I would not give a fig for the simplicity this side of complexity, but I would give my life for the simplicity on the other side of complexity." Now, I've just received a note that at this stage we can't share the slides I've prepared, but I'll go through them. You'll get a copy of the slides, but the important thing is just to be aware of the complexity that has occurred and the changes that have to be made in the approaches to the estate and succession planning. Now, some Australian statistics. In Australia, 59%, roughly 60% of people have a will, roughly 40% of people don't have a will. But for some reason, 100% of people will die with a will. It's either a will you've made yourself or one you get from the state legislation of the particular state or territory you're in, which means that you literally can get something for nothing. But the question is it worth it? Because it's not a will that you might be able to control the outcome of the distribution, so it's best to make your own will. Wills come alive when you die. You can make charitable gifts through your will, also known as bequests. During your lifetime, you can also make tax-deductible gifts, which gives you a benefit for deductions from your income and long-term estate planning. Unfortunately, charitable gifts and bequests have been the one area that has not been touched by the new budget, so the old rules and procedures still apply. After death, you can use your will to give specific assets. You can avoid capital gains tax and stamp duty up to a point. However, as we go through, you'll see that there will be a reckoning around about the end of June next year when you'll need to revalue all your assets, investments and trust and so on, because there'll be capital gains tax issues involved. At all times, try to make a will avoid an intestacy. That's where the will comes in from the state or territory, and you have no control over how it works. And also, testamentary trusts are still important, but are more limited in scope now because of the changes in the law. I also want to talk about powers of attorney. So wills come alive when you die. Powers of attorney operate when you're not dead, but you don't know you're not dead. They die when you die. You've got, in Victoria, 3 specific types of powers of attorney: a personal enduring power of attorney, a financial enduring power of attorney, and the medical treatment decision maker power of attorney. I also want to talk about advanced care directives just briefly. These are documents that allow you to anticipate the kind of care you want when you are not able to provide instructions as to care either in a hospice or when you have a limited time to live. And it covers the instructional matters that you want to communicate about your the ability to consent or refuse medical treatment. It also covers the values you have for your preferences and what matters to you. Now, one of the things that you'll find on the slides is an estate succession planning flowchart, because I've divided it up into sole assets, joint assets, company assets, trust assets, and superannuation assets. And we focus on the triggers for management and control and succession of these particular entities. Because when you are looking at succession and estate planning, you also have to look at any entities you have, like companies with shares, which are personal assets, which can be involved in your will, or even powers of appointment under family discretionary trusts, which, depending on the trustee, you can also help control through your will. As Christy said, there are significant financial assets moving between generations over the coming decades. And what it means is that there was an article in the Australian Financial Review, which I'm referring to now, where proactive estate succession planning to protect assets and ensure wishes are carried out is so important. Plan for the worst and hope for the best, as opposed to failing to plan is planning to fail. You start your succession conversations years before the transition, not weeks or months. Avoidance in these discussions is common, especially among parents or those who control the assets and entities, in not wanting to deal with it because it means giving up control. And they kick the can down the road instead of addressing succession issues until such time as a crisis occurs, illness or death, which will force an action. And that's what happened in that financial review article. It was a family business. Children were wanting to take over. Dad wasn't keen. Fortunately, moves were made before Dad died. He never got to see the fruit of the efforts in which the children took over, but at least it was put into place. Now, that means that when planning for estate and succession are not managed well or at all, hardened wealth built over lifetimes can sometimes become entangled in legal proceedings. Written plans avoid assumptions, misunderstandings, and later disputes, identify the assets and entities tied to the individuals early in the process for the management, control, and succession issues, address equitable outcomes for children who don't want to participate in the succession or the business before dealing with estate or business succession. Be prepared for emotional difficulties and engage professional advisors with the experience and patience to manage family dynamics. KPMG did an analysis back in January, which came out with these key points. The great wealth transfer has already begun. Baby boomers are Australia's wealthiest generation overall. They have an average net worth of almost $2.5 million. They're downsizing properties, they're moving capital into cash and superannuation, and they're either retiring or handing their wealth to their children. Generation X holds more property wealth than any other generation, an average of about $1.5 million in dwellings and land, compared to baby boomers who hold just under $1.4 million. The average millennial household has a net worth of $950,000, but is loaded with almost $500,000 in debt, which is the highest of any generation. So these things have to be taken into account. Note this on the KPMG analysis: households aged 25 to 34 recorded the fastest wealth growth of any age group over the past 5 years. It's up 63%. KPMG has noted too, the low interest rate window has closed. So on the way in this morning, there was some speculation about whether there'll be an interest rate rise. It's entirely possible, so be aware. The age bracket of those 55 to 64 holds the highest net worth of any group at $2.5 million, roughly. And roughly, that's made up of about $1.5 million in property and $750,000 in superannuation. So you can see the growth and the movement here for what's coming up, because clearly superannuation is the next big story. But because of the changes from the budget, you have to be very careful. Younger Australians actually are building superannuation from a higher base than their parents, and a significantly larger retirement balances come into their hands despite today's affordability challenges. Baby boomers still lead, but Generation X takes the property crown. Now, I go through the topics that Christy had put out in the information sent to you of why the best plans are well bit before needed, protecting family wealth, reducing disputes, tax-effective ways to provide for families, friends, and charities, how different structures preserve wealth and long-term wishes, and practical considerations for greater confidence. Now, if for whatever reason we're still not able to get the slides up, I'll go through them, but you'll get, of course, a copy. Now, the tax reform at a glance from the 2026 federal budget means that there are key changes in the following areas. Watch out for Division 296 of the superannuation tax, because you've got, of course, an additional tax on super balances above 3 million and an additional tax on superannuation balances above 10 million. The CGT discount has been replaced and will come into effect as of the 1st of July next year. So forget the 50% discount as of the 1st of July. So it's been abolished for individuals, trusts, and partnerships. There's a CPI indexation and a 30% minimum on the real gains that you make. Pre-CGT assets are going to be reset on the 1st of July 2027, which means you'll have to get new valuations. So any pre-1985 CGT exempt assets will be brought into the CGT regime because there'll be a deemed disposal and acquisition as at the 1st of July 2027, a little less than a year to go. So it'll be at market value. It affects wills and trusts as well, so you need to take that into account. So negative gearing, well, on the 12th of May this year, negative gearing has been restricted to newly built residential property for acquisitions after the budget night, and existing properties have been grandfathered. So those who want to leave their investment properties to their children down the track need to check on the tax regime in place at the time. Also, very much be aware of the discretionary trust tax for minors. So a 30% minimum tax on discretionary trusts distributions as the trustee level. It's a non-refundable credit to non-corporate beneficiaries. So the tax office hates family discretionary trusts with the fire of 1,000 suns. And what it means is that it's been penalizing distributions to underage beneficiaries at penalty rates. This, however, means that there are certain exemptions that have been managed to be achieved. So, exemptions from the 30% minimum trust tax, fixed testamentary trusts, including superannuation and estate proceeds trusts. So that means that you have to be specific about the beneficiary who is to receive a benefit for concessional tax treatment as a minor. Charitable trusts, again, still retain the same kinds of exemptions and procedures as before the budget. So charities are still a good bet. That's a little hint. St. Vincent's would like to be able to get some assistance. Special disability trusts are also exempt. Deceased estates, complying superannuation funds, primary production income for all you farmers out there. Discretionary testamentary trusts, as at the budget night, 12th of May, and established for genuine testamentary purposes, which the government confirmed on the 18th of June. But here's the trick. What does the phrase genuine testamentary purposes mean? You have to guess. It hasn't been made into the legislation yet. So you've got a slide that shows critical commencement dates. I've just gone through those. I'll go on. and why best plans are built before they're needed. Now, without a valid will, you get intestacy. Your de facto partner of less than 2 years may receive nothing. There are no testamentary trust provisions, and all income to minor children will be taxed at penalty rates. You don't have any guardian nomination for minor children. Superannuation proceeds trust can't be constituted without a valid will framework. However, I dealt with one recently in which the super fund paid directly to the mother of an infant beneficiary, and a superannuation proceeds trust was able to be done on that with exemptions for the minor beneficiary. Business succession has been left to chance, and shareholder agreements are becoming more critical than ever. But sometimes there are no shareholder agreements. So those with businesses who have trusts and shareholdings that you want to pass on for the control and management of the company, be aware. Delay can be even more costly because of the 2026 reforms. So pre-1985 or pre-CGT assets, you get a deemed historic disposal of assets on the 1st of July next year. This means that family farms, old business interests, historic land are all brought into the CGT regime. Assets gifted or held in wills must be recharacterized urgently. Testamentary trusts established after the 12th of May this year may be subject to the 30% minimum tax. Legislation is still on the shelf for that. Fixed testamentary trusts remain exempt because that means if you're going to leave a right to occupy in your property and your will, you need to specify and name specifically the person who is going to occupy and not leave it at the discretion of the trustee to choose among family members. Superannuation estate planning, again, Division 296, that's going to be an issue that bites. Negative gearing grandfathering, properties purchased before 7:30 p.m. on the 12th of May this year are grandfathered, and estate holdings, pre-budget properties should document this date carefully. So, steps to take pre-succession planning. So before you start planning, you've got to prepare. So 80% is the preparation, 20% is the actual steps. So update your wills, take a look at what your wills say, do an inventory of your assets and map out capital gains tax implications, do a superannuation review. Binding death benefit nominations sometimes lapse after 3 years. Depending on what fund you're with, if you have a self-managed super fund, often the super deed that you do may say it does not lapse. But with industry firm super funds, you will have sometimes a 3-year limit. Don't forget the $3 million threshold for tax and the $10 million threshold for tax on the tax. Trust deed reviews. Look at your family trust deeds because the minimum tax is going to come in. You will have a 3-year rollover window from 1st of July next year to decide on what other entity you roll over into without having problems with a capital gains disposal. So some discretionary trusts may become fixed trusts, or they may decide to go into a company structure with specific shareholding entitlements. Look at your powers of attorney, because here in Victoria, the powers of attorney regulations were changed back in 10th of August last year, and new prescribed forms must be used. The old forms are no longer valid. Business succession, review your buy-sell agreements, your shareholder agreements, your partnership deeds. Consider whether the small business capital gains tax concessions can be maximized, because like charities, the generosity of the budget says they still remain in place. So document your company constitution and your director succession procedures. Now, protecting family wealth and reducing risk of failures. So, a will is good manners, but a will can also be challenged by people who feel they haven't been dealt with fairly. So, the eligible applicants, immediate family, can even be grandchildren, stepchildren, domestic partners, if they're part of the family group. The proper maintenance and support requires a financial need, so a moral duty applies, which is one of the few times you'll find the word morality in a piece of legislation dealing with the law. But moral duty without a financial need on the part of the beneficiary won't get up. Watch out too for those who have assets in New South Wales, because the notional jurisdiction means superannuation, joint holdings and property, and even trust distributions can be brought in as part of that notional estate to be included in your overall estate if there's a claim. So be on the watch, be alert but not alarmed, and also notice the issues with intestacy, because you've got issues where there was a case where a man separated from his wife, did not divorce her, took up with another woman. He died. There was a dispute between the still wife and the new domestic partner, and the court had to sort it out. So, risk factors in making wills with distributions. Unequal gifts to children, but there's no law that says you have to make an equal gift. It depends on the children's circumstances. Blended families, competing interests of the current spouse and children from prior relationships have to be taken into account. And the thing that sends a chill down my spine, people come in and say, I just want a simple will, but the family dynamics are complex, blended, and sometimes toxic. Informal asset transfers before death that occur, like joint tenancy survivorship, binding death benefit nominations and superannuation, and bucket company distributions could be brought in. But watch out too for bucket company contributions coming up in the near future, because you'll notice the tax rate for trading companies is 25%. Bucket companies, which are mainly passive income, are taxed at 30%. Capacity concerns. Watch out when you're trying to do a will. Make sure if there is a family member who wants to make a will, get medical records and doctor's opinions. Watch out too for wills that have been generated by artificial intelligence. There's been a court case on that. The courts will scrutinize that very, very closely. And if you don't have medical records, try to get at least some documentation on your understanding and the understanding of any carers. Powers of attorney, I've mentioned that before. I won't go into a lot of detail on that. It's on the slides. I'm very aware of the time. Tax-effective ways to provide for your family, friends, and charitable causes. Hint, St. Vincent's Foundation. Critical updates. When you look at fixed trusts and discretionary trusts are going to get hit with a 30% minimum tax on every distribution for beneficiaries. So, what you look at is a change in the way you might want to organize your entities, because you've got the issues for the beneficiaries of a testamentary trust, where the trustee has to hold back 30% automatically of any distribution, and the beneficiary is left with the remaining distribution, but the beneficiary will also be assessed on tax for that distribution. So it's almost like a double hit. Now, traps in the budget 2026 for testamentary trusts under a will. What's pending is the definition of a genuine testamentary purpose. How do you determine what it is? What's been enacted is estate-sourced assets only, which are part of the original trust, will be able to achieve a concession for distributions to minor beneficiaries from the income generated from those assets. But any injections of after acquired assets, once the trust has been set up, that's a different matter. They will not be available for concessions. So Pre-CGT assets and testamentary trust, again, the deemed disposal coming up on the 1st of July next year. Enacted main residential exemption trust deed must include an occupancy clause to a specific person. Otherwise, you do not get a tax concession and a CGT benefit from any rollover. What's pending is that company beneficiaries will be excluded for trusts formed on or after the 1st of July, 2028. So this is where you've got to, again, look at your structures and anticipate now. Get in place. Any will naming a company as a permissible object must be reviewed. Also pending is the corporate beneficiary double tax, which is an effective tax rate of 42.9%. So no minimum tax offset for corporate beneficiaries. Trustee pays 30%. If the company receives, say, $70, it pays 30%. Corporate tax, which comes to $21, is a total of $51, which the 30% the trustee has to withhold and the percentage that the company has to pay in tax. So what's enacted is the 50% discount is going to be abolished. So anyone who has a investment now, which you've held for more than a year, you'll still be able to claim the 50% discount on disposal. But as of the 1st of July, revalue it because you got the CPI plus 30% after that. And what's pending are franking credits will be non-refundable under the minimum tax. So even if you have a minimum income, which means that you wouldn't have to pay tax on, you will not get another benefit for a tax credit on franking credits. Superannuation, death benefits and proceeds trusts. This is where make sure if you've got a superannuation trust, get your binding death benefit nomination in place, get your will set up, your powers of attorney set up so that if you die or lose capacity, your legal representative can handle any renewal of a binding death benefit nomination that needs to be made. And that you need to also look at the possibility of a superannuation proceeds trust for infants who might need a benefit for concessions from the tax. Most important now, charitable giving in wills, trusts, and tax. So again, charities still receive the same benefits and you still receive the same deductions for gifts during your lifetime. But what it also means, if you have a gift of a specific asset to the St. Vincent Foundation, such as property, real estate, or shares, you do not get an estate tax discount, but the gift is free of capital gains tax on the disposal of the asset to St. Vincent's, which is a deductible gift recipient registered charity on the ACNC, the National Charities Register. And it means that it helps them with what they have to spend on acquiring plant and equipment, operating tools, education and services for staff, and also services for patients. Now, different structures preserve wealth and long-term plans in different ways. I've got a slide that deals with the structure comparison and wealth preservation for private companies, discretionary family trusts, fixed or unit trusts, self-managed super funds, or industry funds even for that matter, partnerships, and joint tenancies. Because time is starting to run short, I draw your attention to that because it is important to at least be aware of what is coming up for all of these entity ranges. Now, a deep dive into wealth transfer because of the capital gains tax reforms. I've gone through already the 50% discount is going to be abolished. CPI indexation replaces the discount. There's the 30% minimum on capital gains after CPI. Pre-CGT assets are deemed disposal coming up on the 1st of July next year. Small business CGT concessions, thankfully, still retain in full the 15-year exemption, the 50% active asset reduction, the retirement exemption, the rollover relief have all been preserved. So over 90% of active businesses still remain eligible. Estate planning implications, wills holding pre-CGT assets, there's going to be that deemed disposal on the 1st of July next year, so the beneficiaries will inherit at the 1st of July 2027 market value, even if there has been a pre-CGT asset which would normally have been exempt. Testamentary trust, as opposed to trusts, living trusts, inter vivos trusts, such as discretionary trusts. Pre-CGT assets face the same revaluation, deemed disposal issues. Authorize the trustees and the trustee to make the transitional market valuation election. Very important to give them that power. Additional deed clauses are essential for all the practical steps, and you need to get advice on that. Notice that the tax office has this lovely Division 128 in the Tax Act, which is a CGT rollover on death. But it's not the same as the 50% discount. Division 128 still applies, but the asset inherits the deceased CPI indexed cost base post 1st of July next year, and not the pre-death 50% discount base. Negative gearing on investment properties acquired before 7:30 p.m. on the 12th of May are grandfathered for negative gearing, but you're not going to get this CGT discount because of it's been abolished. So even grandfathered properties will be subject to the revaluations of post-2027 gains. Arrange for market valuations now to prepare for the 1st of July 2027. Practical considerations for planning with greater confidence. I give a practical action checklist for things that are urgent to do before July 2027, that are urgent to do before July 2028, and ongoing foundations for action, which means monitor Treasury legislation on the minimum trust tax. There's a draft bill defining genuine testamentary purposes and the trust establishment event of whether it's by will or by death, as opposed to asset transfers into a trust. Confirm self-managed superfund deeds, validity, binding death benefit nominations, pension reversion nominations, and that may be a partial answer to the question about putting a pension into an accumulation fund. If there's a reversionary pension from the deceased spouse that was arranged prior to death, the surviving spouse still gets the benefit of the deceased spouse's pension without having to transfer a lump sum anywhere. Align with estate planning, consider private ancillary funds or public ancillary funds for charitable, philanthropic, and tax benefits. So review your wills, review your powers of attorney, trust deeds, company documents, and the arrangement by which you hold other assets. Unresolved issues require further investigation, where the legislation is pending, policy is unclear, and guidance has not yet been issued. Okay, discretionary trusts, trust restructure rollover relief, the apportionment formula for transitional capital gains tax election that the tax office is going to apply. What are the explicit exclusions that you'll receive under a superannuation proceeds trust, and the issue of a possible 30% minimum tax. Trust-owned dwellings for main residence capital gains tax exemptions, and Division 296, of course, for self-managed super funds. Now, in summary, plan early, protect your family wealth, do tax-effective planning, get the right structure for the purpose, act now, but seek specific advice. Some of the best estate litigations we get are from homemade wills or news or wills from the local news agent, because sometimes people just don't get it right, and that costs a lot more money than it would have if you'd done it right in the first place. So consider the alternative, and I'll leave you with a quote from Francois Rabelais, who was a French doctor, monk, and satirist who died in 1553. His will allegedly was very straightforward. He said, "I have nothing, I owe much, and the rest I leave to the poor." And I'll leave that with you. Thank you, ladies and gentlemen.
David, thank you so much. That was fantastic. And I'm sure I speak for everybody when I say there was so much expert knowledge in this webinar you've just delivered. And I'm sure many of us will watch it again and again to take away those valuable insights that you shared. So thank you. This does bring us to the end, so I will be sharing the slides that David has very graciously created for us and the recording of the webinar in the coming days. Again, thank you so much to everybody who joined us today. Thank you to David for your wonderful time and you know, very generous to share this time with us. And any questions, queries, please don't hesitate to contact me at the Foundation. I look forward to seeing you at our next webinar. Thank you so much. Bye.